Now, here's a trivia question for all of you. You ready? What part of the New Jersey Constitution of 1947 gives you the right to keep and bear arms in the state of New Jersey? And the answer is?
None. There is no state constitutional right to keep and bear arms.
Talk about that a little bit, and Burton v. Sills in particular, by the way.
Burton v. Sills was the first constitutional challenge, and there were several grounds for the challenge of the firearm laws. But the state Supreme Court upheld New Jersey's firearm laws, and it upheld the laws on two prongs, basically. One was that at that time, it was believed that the Second Amendment, the federal constitutional Second Amendment right to keep and bear arms, was a militia clause, essentially. It was not an individual right, but a group right for the states to maintain militias. And the second prong on which Burton v. Sills rests is the fact that, that the Second Amendment of the federal Constitution was never incorporated into the states. And so our primary case law, Burton v. Sills, which has upheld the constitutionality of New Jersey firearm laws, rests on those two legs. And, of course, as we're going to see in a minute, those two legs now are questionable, because in 2008, the federal Supreme Court of Heller versus the District of Columbia came along, and in that opinion from the U.S. Supreme Court, it was determined that the Second Amendment is indeed a fundamental individual constitutional right, not a group right. And then on the heels of Heller came the Mcdonald Decision, Mcdonald v. City of Chicago, and that decision was the one that was asking the question, is the Second Amendment incorporated to the states via the Due Process Clause of the 14th Amendment? And our federal Supreme Court has held that the Second Amendment is indeed one of the parts of the Bill of Rights that is incorporated to the states. So the question that leaves obviously hanging in the air is, what is the vitality of Burton v. Sills? Now that these cases have been decided, the federal Supreme Court has made clear that the citizens of every individual state enjoy a Second Amendment right. And Burton v. Sills now stands in opposition against that. And so the question is, has it now been overruled?
Well, we'll try to take a little peek and come up with some predictions on how the Supreme Court may handle these issues. When I say the Supreme Court, I mean the New Jersey Supreme Court, in light of these two decisions by the United States Supreme Court. But in order to do that and put this in a little bit of a deeper context, we really have to get into the Heller case and to the Mcdonald versus City of Chicago.
Heller was a case that arises out of the District of Columbia, and the District of Columbia enacted some very strict gun control laws. They basically prohibited possession of handguns at all within the district, and even long guns that were legally possessed under the rules that were adopted had to be kept unloaded and disassembled or trigger locked unless they were in a place of business or lawfully used for recreational purposes. Heller was a special police officer in the district, and he wanted to keep a handgun at home. He was willing to comply with registration requirements. He was willing to have his gun licensed, but based upon these ordinances that were established, they refused to allow him to keep his gun at home, and so he filed suit against the district. And the primary question that the suit required to be dealt with was whether or not the D.C. regulations violated the Second Amendment. When the case goes up to the Supreme Court, as Rich was telling you, the court had to construe what the Second Amendment dealt with, and they talked about the language in the Second Amendment that dealt with, quote, the people, end quote. And in dealing with that, they made it clear that by the people, the founders were talking about an individual right of all Americans, not a militia right. Secondly, they had to interpret what keep and bear arms meant. Keep arms, said the Supreme Court, means to have weapons. Bear arms, the court said, did not mean that the only way you had a right to bear arms was through an organized militia. Rather, the court said self-defense of a person or a person's home is included within the constitutional concept of bearing arms. Therefore, said the court, the right of the people to keep and bear arms, quote, guarantee the individual the right to possess and carry weapons in case of confrontation, end quote. Now, that sounds pretty good. However, the court made it very clear that Second Amendment rights are not unlimited, and they provided a non-exclusive list of the kinds of limits that could be put on gun possession. So, prohibiting concealed weapons, possession by felons and the mentally ill, possession in schools, possession in government buildings, or laws that impose conditions and qualifications on the commercial sale of weapons, all, said the court, are and would be appropriate under the Second Amendment. In dealing with the D.C. statute, the court said that since the D.C. statute totally banned handgun possession in homes and effectively required long guns to be made inoperable within the district, that those laws were too broad and violated the Second Amendment. Interestingly enough, the court ducked the issue about whether the licensing requirement itself was constitutional because of the fact that Heller was willing to license his weapons so that the Supreme Court didn't have to deal with it, and given an opportunity to duck an issue, you can almost always count on the Supreme Court to do just that. Crespo is a New Jersey DV case. An FRO was issued, and Mr. Crespo challenged the constitutionality of the domestic violence statute. Particularly, he challenged the weapons provisions, the weapons seizure provisions of the domestic violence statute, arguing that those provisions, in fact, violate the Second Amendment. The appellate division rejected all of Mr. Crespo's claims. The case goes up to the Supreme Court. Our Supreme Court upholds the appellate division, relying primarily upon the appellate division's own opinion. But as to the gun issue, our Supreme Court noted that at the very time that Crespo was being decided, the Mcdonald case was pending before the Supreme Court of the United States, and they noted that case posed the question as to whether the Second Amendment applied to the states, and as you've already heard, and Bob will talk about some more, the ultimate answer to that question was yes. But our court, what they did was to anticipate the possibility that the United States Supreme Court would in fact go that route. And our Supreme Court said in that regard, quote, we need not reach that point because the right to possess firearms clearly may be subject to reasonable limitations, end quote. So, unless the United States Supreme Court finds that domestic violence gun seizure laws are in fact unreasonable limitations under the Second Amendment, the New Jersey Supreme Court has now spoken about that issue and said, as far as New Jersey is concerned, it is not an unreasonable limitation and can be enforced here.
This is the one little hint, then, that we have how the Supreme Court is going to start treating these issues as they make their way up to the court. But this little passage in Crespo is all we have at this point. The Supreme Court correctly presaging what the holding was going to be in the Mcdonald case. Now, just a couple of quick words on Mcdonald. Please be mindful that prior to the court ruling in the Mcdonald case, the only other Second Amendment case that we had at all that anybody had to rely upon was the antiquated 1939 United States versus Miller case. So McDonald versus City of Chicago is the clearest, most direct, and certainly the in terms of setting black letter law, leaves no doubt in terms of what the status of the Second Amendment is vis-a-vis people who want to possess firearms. It's kind of interesting to me that when the court was considering the Heller case, one of the things that they did was trace back the history of possession of firearms in colonial times to kind of get a sense of what how people viewed the use and possession of firearms at the time that the framers were kind of putting the Constitution together.